There's a lot to talk about and unpack with Glenn Gerstell, former general counsel of the NSA. It's good to have you, Glenn. Thanks very much. I should note you worked under both the Obama and Trump administrations. Is that correct? Okay.
That is.
All right. So just looking at the facts here, you've got former federal judge Raymond Dearie is going to hold this hearing today in New York at noon. And at the same time, the Trump team has 2 hours to respond with their latest filing. But they're pushing back. Last night, they pushed back on part of this, saying, no, they should not have to immediately disclose certain declassification information. Remember, Trump said, well, I declassified all this stuff, blanket declassification. I think it's 17 or 18 folks in the Trump White House at the time have pushed back on that. Why do you think it is that his legal team isn't making that legal argument that the former president himself is making?
Well, it's one thing for President Trump to say on his Truth Social website that I declassified everything and there's nothing to see here. It's quite another thing for the lawyers to have to make an assertion in court about that. And it's been fascinating to see that at various points along the way, when attorneys for Donald Trump could have made the argument about declassification, such as when the first set of documents was turned over to the National Archives back in January, or again in response to the subpoena, there was no comment about the declassification. This is just something the president has made up. And now that Judge Dearie, who's a very respected judge who served on the Foreign Intelligence Surveillance Court, has said to Trump's attorneys, I want to hear what arguments you have that support that these documents were declassified. The attorneys have backpedaled. They said, oh, please give us more time. We're not ready to make the comment yet. And besides, if we are going to make that assertion, we don't want to do it before the magistrate who approved the search warrant. We want to do it again before Judge Cannon. Which before Judge Cannon, which to me suggests that they're very aware that their argument is on thin ice, if on any ice at all.
Okay, so what if Trump's legal team does not present that argument? What if they never make the legal argument in these filings that, yes, the former president in some way, shape, or form declassified these documents? Would you say then that Judge Dearie, or I guess it would be Cannon if they're presenting for that, would then say, all right, DOJ, back to you. You can continue your criminal investigation because we have no legal argument here for declassification?
Well, that's not going to be a decision for the special master to make. The special master is simply putting documents in buckets, so to speak, for Judge Cannon to further rule. But based on what the unprecedented decision that Judge Cannon has made, both originally in appointing the special master and most importantly, telling the government, pencils down, don't continue with this investigation looking at these documents, stop the counterintelligence investigation. I doubt seriously that Judge Cannon will take another opportunity to back off her order.
What I find most fascinating and potentially most consequential going forward in terms of what precedent is being set by the courts here is the question of executive privilege and how far it extends and to whom it extends. And this is in Cannon's order a few weeks ago. She pointed to U.S. versus Nixon, that 1974 case, a Supreme Court decision, but so did Department of Justice lawyers, except they see it totally differently. Can you explain how consequential a question it is?
Sure. This is critically important, Poppy. So the doctrine of executive privilege actually dates back to the time of George Washington, who refused to turn over to Congress some records about how the executive branch had negotiated a treaty. And that's the essence of the privilege. It says the executive branch doesn't have to turn over internal deliberations to another separate but equal part of the government, the judiciary or the Congress, or to the public. And that was the basis of the decision you cited, the U.S. versus Nixon, which was a unanimous decision of the Supreme Court saying to President Nixon, no, you don't have executive privilege in this area. And the one case that directly applies here is a later case involving Nixon, involving the GSA, in which there's a famous line in there, which is that the privilege is not personal to the president, it belongs to the republic. And that's a critical issue here. There is no basis for, in this case, Judge Cannon to say to the government, you're not allowed to see your own executive branch documents. That just makes no sense at all.
Glenn Gerstell, thank you so much for helping us understand this a little bit more ahead of this deadline today. Good to have you. Jim.
Thank you.